Assalamualaikum everyone. I am Aqilah Rozi. So me and my friends, we got a law assignment that we need to analyze. So we got two. So this is the easiest one. So I will explain for this one first. So this case is breach specific contract. So wrongful dismissal of servant. This contract is between the employee and employer. So KB Pillai versus Power Form Rubber Product Manufacturing Co Limited. So KB Pillai is the plaintiff. He is also known as the employee. So Power Form Rubber Product, this is the defendant, and they also known as the employer. Firstly, the defendants agree to take the plaintiff as their worker, as factory chemist and production manager. So they do agreements between employee and employer. So written contract of service, the defendants employed, yes, they agree to employ the plaintiff as their factory chemist and production manager. Sorry for that. So for 1 year, from 1st March 1958 to 28 February 1959, with the salary that the defendants offer to the plaintiff, $800 per month. So at 7 March 1958, the plaintiff went to India with the consent of the defendants, and he was after that he did not return until the first week of May. So the defendants was not paid the plaintiff's salary for March and April. So after that, they do verbal agreements for an indefinite period. So these cases has arisen when one day the defendants allege that the plaintiff has committed an act of disobedience in refusing to attend a meeting when called to do so by the managing director. So the defendants make decision to dismiss the plaintiff service. So the plaintiff feel dissatisfied with that result, so he brought an action claiming for salary for March and April 8 at the years 1950.
So for the first case, the issue related to the cases regarding discharge of contract, where the plaintiff is treated by the defendant. The discharge of contract happen when parties to the contract are released from any obligation arises under the contract. From this case, the plaintiff was entitled to give 3 months notice. He should consider working for another 3 months to finish it. So the defendant should have allowed him to work out his period of time, but they breached the contract, which is give him a month's notice. They should give him 3 months notice instead of a month's notice. The plaintiff is therefore entitled to damages in the sum of $1,600 for 2 months salary. So in the result, there will be judgment for the plaintiff for $3,200 with costs.
The law that involved in the first case are Section 40 of Contract Act 1950. First one, discharge by breach. It means when a party, one of the party in the contract may not perform or disable himself to be done in whatever in the contract. The promisee may put an end of their contract. The second one is Section 74 of Contract Act 1950. Where an innocent party in the contract may claim the damages from the other party when they are not demand their damages of their losses.
Okay, this is our second case. This is the tough one. So this case is between Kim Nam Development Sdn Bhd versus Kau Dau Yau. This case is under Federal Court, Kuala Lumpur. It happened at the years 1984. So these cases is brought by some of the buyers who agree to do, some of the buyers who signed up a contract to the appellant. Actually, appellant, he is proposed to develop 2 pieces of land in Kuantan. He want to build a housing estate. And then before that, the cases is arise became complicated because the land actually is belong, the one is belong to him, to the appellants. The other one is belong to other company. The company is the photo trading company. And then the buyers feel unsatisfied to decision that made by the appellant. The appellant decide to not build the house that he proposed. So these cases is arise because when he decided he did not want to build the house. And then one of the reasons why the appellant did not want to build the housing estate because the other 1 pieces land that belong to the photo trading company, appellant applied to do subdivision and conversion. But the one condition that he need to do in order to do the subdivision and conversion, he need to, this was the granted subject to the conditions that a number of the lot should be reserved for Bumi Putra. So after that, the appellant decide not to build the house that he planned before with the buyers. So some of the buyers not feeling satisfied with his action.
Hi, so I want to share what I have understand from this case. So basically this issue is related to the specific performance which is under remedies, where the respondents are claimed for their rights by obtain the compensation for a wrong. So specific performance is an order for the court ordering to the deed to perform his promise that he has made. From this case, we are of the view that the appeal should be dismissed with cause. This is because the respondents are entitled to damages only instead of specific performance. So, there will be an order that the court below should proceed to fix the damages. So in the end, the deposit should be paid to the respondent to the account of tax cost.
Section 24 of Contract Act 1950. This section is about consideration of or object of an agreement is lawful unless it is forbidden by a law or fraudulent. It requires or suggests harm to another person or property, or the court view it as unethical to the public policy. So institute within 6 months from the date of the act and not afterward. The third one that court refer the law is about there is no any action can be taken to the minister or government or someone else who is work under the government unless by someone the 6 months after the date that the things happen, or the action be taken by the government or someone who work under the government. Rule 11 bracket 1 of Housing Development Contract and Licensing Act 1966. If the seller housing developer cannot fulfill their agreement towards the seller, the minister can their power to take an action under section 12 in order or for the purpose to safeguarding the of the purchaser license housing available.